Yeah.
And we're back again with another episode of the Counterlawfare Report with Brian Vukadinovich. Brian, how are you?
Real good, Jason. Good to be back on.
Great to see you. And tonight we're going to be delving into really one of the most important topics that this show is all about. It's prosecutorial misconduct, it's manipulation of evidence, police misconduct, judicial misconduct. What have you prepared for us today, Brian?
Okay, well, we have several things that we're going to show the audience today. We're going to have several documents with cases that I was involved with in several false arrests and vindictive prosecutions that is going to prove by the evidence that's shown in the documents that were written by the police and the prosecutors that they lied and concealed evidence in the cases against me, which will serve to show the public that these are examples of what is taking place out there in society today, with so many people that are being wrongfully convicted, innocent people that are being wrongfully convicted of crimes all across the country and serving substantial jail time, prison time. Some, I know not too long ago I saw a case where somebody spent 23 years in prison, and then it was later determined, because now we have DNA evidence and so forth, that he was innocent of the charge and there was a bogus charge brought against him. And you're showing here on the screen there was a case. I believe this gentleman here spent 40 years in prison.
Whoa.
40 years of his life in prison, and even after the prosecutors in that case learned of exculpatory evidence that would exonerate him, that would show his innocence. 45 years, it says here, not 40, but 45.
Amazing.
Okay, the prosecutors did not disclose that evidence to the defense team. And that's a shame. That's an absolute disgrace. And that's why we're going to have this show, and we're going to encourage a new law in this country, an eye for an eye law. It's only fair that if prosecutors take part in unjust proceedings where they're concealing information, concealing evidence from the defense team, and police are getting on the stand and lying in order to get people convicted of crimes that they're not guilty of, those wrongdoers, those prosecutors and those police, corrupt prosecutors and corrupt police, should be required to spend the same amount of time in prison that person had to spend. For example, this gentleman here, Mr. Phillips, spent 45 years in prison based on information that was withheld from him. The prosecutors in that case who took part in that withholding of that information should likewise have to serve 45 years of their life in prison because they withheld it. They allowed an innocent person to go to jail, and that's unconscionable. And there is a need. The only way that we're going to correct that problem in this country is to have an eye for an eye law. And I believe you're going to talk later.
Sorry to interrupt you, but that's like a life sentence, 45 years in prison. There's no restitution that can be given. I mean, even if the guy was, 20 when he went into jail, he's 65 now. He's missed out on everything.
Exactly. It's a crime. Think about it. If let's say somebody's 20 years old, this gentleman from Detroit was 27. He's going to turn 72. He spent the better part of his life, basically his entire adult life, in jail based on information that could have exonerated him of the false charge, which the prosecutors withheld from him. And it's just a shame,
and
terrible. That needs to stop.
It's not even the better part of his life. It's his entire adult life, the beginning of his retirement. I mean, this is someone who is going to have a difficult time even acclimating to society. So I think, if I understand you correctly, the point of this eye for an eye law, it's a little bit of a kind of a Hammurabi sounding name, but the idea is we really want prosecutors to avoid this. If they know that they could face 45 years in jail for doing this incorrectly, particularly if they know there's exculpatory evidence, they have to feel the pressure of that. I mean, for this guy's life is over.
Exactly. That's the point. Police officers who get on the stand and know that if they lie and get a person put in jail that they, for whatever reason, don't like for whatever reason and so forth, if they know they can get away with that, they're going to do it. And history has shown us that that's exactly what's been taking place in the country. And if they know, and also the prosecutors, the same with them as well, if they know that there is information there that could exonerate the person, first of all, there shouldn't even be a trial because the prosecutor on his or her own should not even be pursuing that case if they know of exculpatory evidence. So if they push those cases and actually lie to get people to go to jail and withhold information, if they know ahead of time that if they get caught, and we're starting to catch these people now because of the new DNA structure that we have now, where we're able to show things that weren't quite appropriate that were taking place back in those days before the days of DNA. If they know that if they pull that number and get caught, that the consequence for it will be for them to also spend numerous years in jail, they are very definitely going to think twice about doing it.
Yeah, strong deterrent for sure.
Exactly.
And as you've told us, Brian, this is basically standard practice that prosecutors and judges know there's absolutely no repercussions for them doing this. They can do it vindictively. They can do it, in the case of for-profit prisons, there was that judge in, I guess, Pennsylvania, was it, that was sentenced to jail for the Kids for Cash scandal. So this is a topic that's gaining some attention, and I'm glad you're bringing it to the attention of our viewers here at the Counterlawfare report. What was going on with this guy? I mean, this kind of speaks to what we were saying, that once you're in jail for a certain period of time, this guy, now he's free, but he's bewildered. These guys are in jail for a long time. They can't develop life skills. They can't develop relationships. They're just sort of ruined.
Yes. Well, think about, just the psychological problems that will develop from that, from spending all of those years in jail. And then when you finally get out, the major adjustment that you have. And also, unfortunately, even though you're proven innocent at a later time, and in this gentleman's case, Mr. McKee, it was 47 years, even though there's a determination made that you were innocent, there's a stigma that is attached to you for the rest of your life. People will still think, well, he probably had a slick lawyer that got him out after all of those years and so forth. That there's a stigma that's attached to it, and it's hard to get jobs. It's hard to walk into a place and get a job when the employer knows that you've spent 47 years of your life in jail. They're basically not going to want to hire you. So there's a lot of things attached to that, and the state governments. Some of them have laws where they compensate these people who have been unjustly convicted and in prison, and some don't. For example, the state that I'm in, Indiana, it does not have a compensation provision in the law in Indiana.
Wow.
In other words, they can put people wrongfully in jail for years in Indiana, and when they get out, after determination is made that they were innocent, should have never been in jail in the first place, it's too bad for you in Indiana.
Wow.
Because Indiana is backwards. It's a backwards state, and there's plenty of other states. Now, there are some states.
That basically creates a scenario where if a prosecutor wants to, or a judge or a cop wants to punish you, they can just do it, and they know even if you're later found to be innocent, you've been punished.
Absolutely. Well, I can tell you, I'm Exhibit A, because it happened to me. I mean, as we talked before, I went through 10 prosecutions, false arrests, vindictive prosecutions, and it cost me a whole lot. Now, here's an example. I went to trial, and I was acquitted of the charge. And in this particular case here, the sheriff testified after my trial on a civil deposition that he felt that there was not going to be a conviction against me because there was no evidence to support the charge, the DUI charge that they tried to pull off against me. So the question is, if the sheriff, and his name is Tim McCarthy, he's the former sheriff of Porter County, Indiana. So the question is, if McCarthy, the sheriff, felt that there was no evidence to back the charge, then why was I being subjected to the prosecution in the first place? But if they want to get you, these are the extremes that they'll go to do it. Now, here's another example. Here's a letter from the Porter County prosecutor at the time. His name was Dan Burning. He received a letter from the deputy attorney of the state, deputy attorney general of the state of Indiana, where I was trying to get information of what was taking place against me. And the deputy attorney general, his name was Clark, Mr. Clark, I subpoenaed information, and he asked Burning, the prosecutor, for all of his information about me. Of course, the information he would have had about me would have had a great deal of information that I was being set up by the police in Porter County and the adjoining counties here, where they were working overtime to try to get a wrongful conviction against me. Now, what did the prosecutor Dan Burning, tell the deputy attorney general at the time when he received the request for my information? He told the deputy attorney general that they couldn't locate the files against me. They were misplaced and they couldn't locate them and so forth. And very importantly, if you look on the letter here on the bottom where it says in regard to plaintiffs and then going on to the next page,
yeah,
it says in regard to plaintiffs request number 4, here's what Burning, the prosecutor, told the deputy attorney general. I am unaware of any such information. Now, he went on to say, in regard to plaintiff's request number 6, I believe the information about the current charge against us is all that we have. And then he went on to state, if you back it up on the previous page.
Is this one here where he says, even if we
Yeah.
were able to locate old files on Vukadinovich, our answer to the plaintiff's motion to produce number 1, 2, and 5 would be that no such information exists.
Exactly. He's telling the Attorney General of Indiana that even if he has that information, that the prosecutor is going to take the position that that information does not exist. That is a crime. For a state prosecutor to tell the Attorney General of the state that even if they have the information, they're just going to lie and say that it doesn't exist, that tells you right there what is taking place.
How stupid is the guy putting that in writing?
Very stupid. But see, the thing is, there's a lot of stupid people in prosecutors' offices. Not all, but many. And this is the problem that we're dealing with in society. He should have been in jail for that. Yeah. And actually, somebody else to have blame here is the deputy attorney general. When he received that letter, when the prosecutor told him that he would just lie about it, that attorney general should have brought state prosecution proceedings against that prosecutor, because that's actually an unjust action against the law. And that prosecutor, in that case, Dan Burning, should have been taken to task for that. He should have been prosecuted for that. But what happens is the government sweeps that stuff under the carpet, and that's why people such as the gentleman that we just talked about spent 47 years in jail of their life, because this is the kind of thing that's taking place.
Now, Brian, we should add our standard disclaimer that neither you or I are lawyers. We're not attorneys. We're not offering legal advice. We're simply two citizens who are interested in the law and are examining cases that are in the public domain and just informing people of them and discussing what our rights are and what we can do as citizens to try to reform what really seems to be a corrupt judicial system.
That is correct. We are not lawyers, and we're not professing to be lawyers, and we're not professing to give any legal advice. What we are doing is we're doing a public service here by putting information out to the public that you and I can speak to, that is factual information, to inform the public as to the corruption that's taking place in the judiciary with lawyers and prosecutors and police and so forth, just so the public is aware of what's taking place and that the public can take some proactive action if it chooses to do so.
Right.
To correct
now,
these things.
I do want to take a moment also, Brian, to remind everyone that you've written a book called Motion for Justice, I Rest My Case, and you had a really successful book signing event at the Barnes & Noble store there in Valparaiso, Indiana. So I want to encourage people to go to barnesandnoble.com. You can purchase Brian's book either in hardcover or as a digital Nook book. Of course, if you'd prefer to purchase the book from a CIA-controlled retailer, you can go to Amazon.com and get it for Kindle. But the book's been selling very well, and this is Brian's account of his ordeal being put through the ringer by the police in Valparaiso County and the subsequent prosecution of his legal case against the school board for wrongful termination. People can also follow Brian on Twitter. He is there at Motion, the number 4, Justice. And Brian is frequently posting interesting information on his Twitter page. You can keep up with details, of course, of this program, the Counterlawfare report. And Brian is a good person to follow on Twitter. I don't know why my Twitter's not refreshing. There we go. But Brian, you've also sent me some additional information here. What are we looking at here?
Okay, now this is a letter that that came from the Porter County Prosecutor's Office to a prosecutor in LaPorte County, in the adjoining county in Indiana here, where there was an attempt made where Porter County and LaPorte County was getting together. And as I said, there were 10 arrests total. I won 9 out of the 10 criminal court cases in court. And then this particular case in LaPorte County, there was a similar situation that we were discussing with evidence being withheld. There was an affidavit in the case that was withheld from me, where the officer, when he stopped me, he found empty pop cans in my car. Everybody who knows me knows I drink a lot of pop, and everybody who knows me knows that I can't stand beer. And I know there's a lot of beer lovers out there, and there's nothing wrong with that, but it's just not my cup of tea, so to speak. And I was actually at the trial here, and I believe you have the affidavit there, and you can see in the letter here that if you need any other information, just let me know, and we'll work together on this thing here. Now, on this, there's an affidavit.
Which one's the affidavit?
It'll say affidavit of probable cause on the top.
Okay.
And on the bottom of it, it'll say this was prepared by the police officer, where he stated that he found empty pop cans in my car. Now,
is this it here?
No, that's a letter where the McCarthy, the same sheriff who testified he knew they weren't going to be able to conviction against me. He's telling the prosecutor in the adjoining county, Robert Shalagi, that he will cooperate with him, that possibly they could get a conviction against me in LaPorte County. And he even, look at this statement here. A few days ago, a person was fleeing police in Valparaiso and was chased, and this officer did not pursue the matter and was unable to effect an arrest. And then he says at the bottom of the letter, it very well could have been Brian Vukadinovich. Now think about this. The sheriff is telling the prosecutor in the adjoining county, hey, just the other day somebody was chased, and the officer wasn't able to effect an arrest, and he was chased to a home resided by Branko Vukadinovich, who was my brother, but the officer couldn't effect an arrest, and it could have very well have been Brian Vukadinovich. Now, I'll ask you this. For anybody that has any common sense, if the police chase somebody to a residence, and why couldn't they effect an arrest? If that actually happened, with all of the resources that they have, they would have called other police and barnstormed into the house. Just totally ridiculous.
Yeah.
That he would write that. That it very well could have been like 10 million other people as well.
Right.
If it even happened, which I seriously doubt that it ever happened. Now, here's the affidavit of probable cause that this sheriff, McCarthy, got involved with the prosecutor when they were trying to get a wrongful conviction against me. in working together. And at the bottom of this affidavit, it states, now the officer was Michael H. Spears of the Westville Police Department. You can see his signature on there. And on the bottom of the affidavit, way at the very bottom, it says, empty 7-Up. This is what he found in my car. Empty 7-Up. And it says underneath, recovered by Spears, the officer. Now, this is very important because I believe you have the testimony at the trial. Now, I would like for the audience to keep this in their mind now. He wrote down what he found was empty 7-Up in my car. Now, at the trial...
Is this the one?
No, it's the other one. This is the prosecutor. This is the well, we can stay on this one for a second. This is the prosecutor. No, this is... Bring it down a little bit, Jason.
Yep.
Yes, okay, keep going. Now, this is another case where they were tried to obtain a wrongful conviction. This is another one. It'll be...
There's no shortage of them, Brian.
Yeah, I know, and that's you have a lot of information there, and it's very difficult to keep track of every item. But this particular transcript that you're showing here is Nancy Vadic, who was trying to get. She's from Porter County. She is now currently the chief judge of the Indiana Court of Appeals, where the transcript shows that when I was attempting to receive exculpatory evidence in that case, Vadic, the prosecutor at the time, now the Indiana Court of Appeals chief judge, told the judge that there was no such information about me, that the police never wrote any letters about me, and so forth, which was a blatant lie in open court by Nancy Vadic, currently the Indiana Court of Appeals chief judge, because they absolutely wrote letters. And you just saw one of them where McCarthy wrote to the deputy prosecutor in LaPorte County. We just saw that letter on here.
It's really astounding, Brian, the degree. I mean, again, this is a system that's deeply entrenched where these guys have a way of doing this where they just know if the cop says this, the judge says that, this is the way it's going to go. So what we're really trying to do here is disrupt this type of ongoing corruption by exposing the actual documents, the actual words of these individuals, the actions that they've taken, etc., and try to let people know that, put them on alert that you can't do this kind of thing. I mean, here's Nancy Vadic. She's, as you've said, these people get promoted for this type of activity. They're not getting prosecuted. She looks quite happy.
Yeah, right there, Nancy Vadic, the picture you're looking at there. It's actually a sad thing that she's even on a court at all, much less the chief judge of the Indiana Court of Appeals. She, at the one trial in Porter County, and as I said, there were 10 cases total. One of the 10 at a trial, she had to go into the trial. The place was packed. There wasn't an empty seat in the courtroom. Vadic, McCarthy, the prosecutors, the police, the one that withheld the affidavit, Spears, who they tried to get to testify, they all packed the courtroom because it was just like it was a who's who. Well, we're going to finally get Vukadinovich. We've tried and we haven't been able to do so, but if we just keep charging them, something's going to stick. And it didn't work for them because I didn't succumb to their pressure. I always said that we're going to do the right thing and the truth is going to come out. And it was very difficult to get the truth out. The judges, in some cases, there was a judge, Paul Baldoni, who left a lot to be desired. He allowed in LaPorte County for the police officer to come on the stand and tell the jury that he found. Now, remember what we were just looking at here a minute ago with the affidavit where he wrote down that he found the empty pop cans? Yeah. He testified, I don't know if you can find it there or not, he testified in the trial that he found beer cans in my car. He didn't say anything at all about pop cans. He told the jury that he found beer cans. He lied.
That's just flagrant.
Yeah, and he was able to do that because he concealed that affidavit switched it and made a new one. And then when I found out about it, I was pursuing discovery in a federal action to be able to show what was taking place. Then I obtained that switched affidavit. They were very stupid. I mean, if they would have had, well, I probably shouldn't say this, but if they would have had any smarts at all, they would have burned that affidavit that they concealed, because it came back later to haunt them when I finally learned about it. So I was able to show that the police lied at the trial, told the jury that he found there it is right there. On the last, this is the Officer Spears's trial testimony of the Westville Police Department. Look on the last line there. It says, the question at the trial, this is at the trial in front of a jury, what, if anything, did you observe? Now, if you go to the next page at the top.
Yep. Bringing it over here. Sorry, it's a little slow to open.
No, that's fine.
Yeah, we got a lot of pages.
Yeah. It would be the very next page.
Yeah, it's opening. Sorry, I don't know why it's going so slow. I should also add, Brian, that in just a minute here, we're going to bring Michael Barden onto the call so he can give us an update, tell us what's happening in his trial. I think it's an interesting thing for us to look into, because it's we're really starting to see how the Counterlawfare report is really helping people.
Yes. Now, after he was asked what is it that he observed when he was arresting me, here's his testimony, trial testimony in front of the jury. Quote, I just observed several what looked like empty beer cans to be in the back seat. Now, you notice he doesn't say anything about the pop cans. He tells the jury he found beer cans. If he would have found beer cans in my car, he would have wrote beer cans on the affidavit of probable cause, not pop cans. So think about it. He doesn't put beer cans on the affidavit. He puts pop cans. At the trial, he doesn't testify to pop cans. He testifies to beer cans. He lied. He was able to get a conviction through his lie.
Now, there's something else very sinister here, Brian, because you see the way he's saying it. He's saying he saw what looked like empty beer cans. So under tough scrutiny, someone could say, well, do pop cans look like beer cans? I mean, they're aluminum cans. They're the same shape. They're small cylinders. They look like beer cans. He's not flat out saying they're beer cans, so he's kind of got a little legalese way to weasel out of this if the wood were put to him.
Yeah, well, and in all honesty here, I didn't have the sharpest lawyer on the planet. His name was David Noble, which was just a whole other story. He's been disbarred from practicing law. There was a problem with money issues later on with him, but just back in those days when you didn't have a whole lot of money to hire, the fancy defense lawyers and so forth, you just have to do what you have to do, and I paid the price for that. Yeah. Looking back, I wish I would have represented myself, to be honest about it, because I would have handled that a lot differently.
Sure. And on that note, Brian, let me bring Michael onto the call here, and let's see what he can tell us. Let me just add him to the call real quick.
Could I just say one thing here before you do it?
Sure, absolutely.
And I would like the audience to know that in the end, those tactics didn't work either, because after I learned of the concealed affidavit, I was able to show the governor of Indiana the concealed affidavit and the trial testimony, and the governor of Indiana, Mitch Daniels, gave me a part of that conviction. So
that's great.
None of the 10 arrests held.
Wonderful news. So, Brian, we've got Michael with us right now. Michael, how are you, sir? You're looking very sharp.
I'm good. How you doing? I just kept my clothes on from court earlier. I like wearing this suit every now and then, so I just kept it on today. So,
well,
Michael looks like a defense attorney.
That's right. We're pleased to have you with us here, Michael. Why don't you give us a little update on what happened, what led up to today, what occurred today, and what is going to happen in your case, and remind everyone what the charges were and that kind of thing.
I was charged with aggravated assault with a firearm, and one charge of evading police, and one of disrupting disturbing the peace, I believe. And they dropped 2 of those, and I was just facing aggravated assault. And they were going to give me a plea deal for disturbing the peace. It would be a felony class 6, but I would still be a felon the rest of my life. And the probation officer had already contacted me, and I'd signed this plea deal about a month ago. And the more I looked into this, and with the help of you guys and some other, you guys didn't give me legal advice. You pointed me in the right direction to find it myself. And with the help of some other YouTubers that sent me some information, I realized that I had rights that were being violated. And I wrote up on this size font, it's about 2.5-page statement that I wanted to read in front of the judge today to withdraw my plea deal. And there was a couple Arizona rules here that we put in here that show that I'm not being treated fairly, and I'm being given exculpatory evidence, and that I do have the right to withdraw my plea deal. So I put that in this 2-page letter. The judge said that I wouldn't be able to. The judge actually took this. I got it in there before they tried to sentence me today. The judge read it, and then I appeared in front of the judge, and I requested actually to the judge that I be able to read this in front of the court out loud. I'd actually practiced it, and I was ready to go. And didn't get that opportunity. The judge said it's really long. I've already read it. You don't need to do that. So I thought, oh man, this isn't going to be on the record. What do I need to do? And I thought real quick, hey, can I give this to you and put this on the permanent record for my case? And they went ahead. The judge accepted this and put this on the permanent record. And there's a lot of good information in here that I think that getting this information into the permanent case files, it was a really good thing. So,
yeah. And there was some outside interference in your case, wasn't there, Michael? You were under considerable psychological stress when you agreed to this plea deal.
Yeah, and that was in here. And actually, the judge mentioned that in the when he was talking to me today, giving me more time. When he didn't. And I'm sorry, I don't want to jump off track here. Yes, he did. I was harassed by George Swigert, or I'm sorry, yeah. What's the guy's Dave Acton, George? I can't keep
David George Swigert had contacted your attorney to point out that you were going on YouTube and expressing your dissatisfaction with the attorney. Brian, can you comment on that? What is the deal with an outside disinterested party who has nothing to do with the criminal charge, was not a witness, has no substantial information in the case, just contacting this attorney who failed to implore the prosecution to deliver exculpatory evidence? This third party interfered in Michael's case. What are the implications of that?
Well, first of all, one would have to think there's an ulterior motive. Why in the world would somebody from another state, actually, according to the information from the letter, contact the lawyer and throw things out that, it's already a very difficult case for Michael to have to deal with, the things that he has to think about in the case and so forth. And then that's why I felt it was important for Michael, and when he has his new counsel now, his new lawyer, to bring whoever wrote that letter into the court proceeding there, put him on the stand, and find out exactly why that letter was written, because it just doesn't make any sense that somebody who wouldn't know Michael, isn't even from the same state, much less the same town or same area, would contact his lawyer. There's a lot of serious questions there, and if there's justice to be served here, there shouldn't be any interference going on in any way, shape, or form. Michael's lawyer was an officer of the court, just like a judge is an officer of the court, and it's inappropriate to contact officers of the court for ulterior motives. What was there in that letter that would have served the interest of justice? And I looked at that letter, and I didn't see anything other than something going on in the mind of somebody that was trying to twist things around and somehow corrupt the proceedings, where Michael was going to have a more difficult time than he was already experiencing in the case. So I think it would behoove Michael to have his new lawyer pursue that and ask the judge to have that particular person who wrote that letter to come in and put him on the stand and ask him the reasons that letter was sent. Because anybody with an ounce of common sense in their body would look at that letter and say, what was this all about, other than some type of ulterior motive to screw the proceedings up in some way where justice isn't going to be served? And that's wrong, and Michael should pursue that.
And you know, for people who are seeing Michael for the first time, Michael, of course, you've appeared on Crowdsource the Truth in the past. You've told us about how you've experienced harassment. Brian, of course, has experienced harassment from the police in Valparaiso. This guy who was chasing you in his car and gave a false statement, said that you followed him, which is simply impossible due to the fact that he arrived at the location of your home. This guy was an ex-police officer, so it seems like there's something going on. You've told us about how you're a targeted individual and that this ex-police officer was participating in that targeting. Now, it's interesting because I haven't, before you and I met, I haven't identified myself as a targeted individual, but of course you raised that notion to my attention, and I haven't experienced the type of targeting that you have, but I have been targeted on the internet through a series of harassing videos. I've been targeted by harassing lawsuits, and coincidentally, the creator of those videos, the plaintiff in that lawsuit, is the same guy who has interjected in your criminal case. So I agree with Brian. There seems to be some sort of ulterior motive there. What did the judge say about all this, Michael?
He didn't mention the interference with Mr. Swigert there, but I would like to bring that up again the next time I go in, and maybe get him in here. So get him here to visit Arizona so he can explain to himself why he is doing this, you know, why he's interfering in my case. Why would he send a letter the day before I have to make a decision for this plea deal, you know, and give me all this information, new information I have to process.
Yeah. Michael. Hey, Michael, did your former lawyer it's my understanding that you just fired him, correct?
I did, yeah. They called it withdrawing, but when I called him, I basically said fired.
Right. It's a way to show face where they don't want to make themselves look bad, so they'll just say they withdrew. But we know he was fired because you fired him.
I make that clear in this statement that I had. Right.
Now, did he make any attempt on your behalf to ask the judge to pursue that matter against in relationship to that letter that was written to him?
They did not ask the judge for anything at all. They had the front desk lady call me, the receptionist. They had the receptionist call me on Friday to let me know.
From the law firm.
From the law firm.
Yeah.
Yeah. Called from the law firm to let me know to be in court at 8:30 on the dot. Monday morning, I said nobody wants to talk with me to you know, make sure we're all squared away before we show up. Says nope, just be there at 8:30 on the dot. So I showed up at like 7:30 or so this morning. Checked out the docket. It says court starts at 8:29. And you know, I had to go in there and make sure that I talked to the courtroom supervisor and let her know that I wanted to be heard by the judge. And my attorney asked for nothing at all other than to withdraw from the case.
Well, there's no way for the judge to know about that letter then, if your attorney didn't inform him of that letter.
Yeah.
So
I had
for
to
the judge to do something, you or your new lawyer will have to bring that to the judge's attention.
Well, I did give him the statement. I gave it to him, and he said that he did read it. So and then they actually put it into my permanent file. I asked them to put it on record, and they went ahead and put that entire statement into my permanent court case record.
But there was no request made to actually bring the letter writer into court, though, correct?
Oh no, I'm sorry, I didn't hear that right. No, there was not. There was no talk of any of that. So we'll have to go over that with either this public defender that I'll be working with, and then I'll just have to try to tell him where I want to go with this stuff, or if I can raise enough money between now and then, I'll try to hire some other attorney. Maybe somebody can give me a good recommendation of somebody here in Arizona. It's going to be tough, but maybe I can hire another attorney and do that.
Well, it would be a good thing if your lawyer would return your money back to you, because he obviously didn't do a very good job in your case, and he needs to return the money back to you. Hey, did the judge make a ruling on your request to withdraw the guilty plea?
No, they did not. They did not withdraw the plea. They just, I can't remember the word they used, but they basically gave me more time. They said, we'll give you till January 7th to find new representation, do whatever you need to do to get your payment back from the other attorney, and January 7th is your next court date. And actually, I walked out of that place without getting any paperwork. Nobody told me anything. I know my court date, but I didn't get any paperwork. I didn't talk to anyone really. I walked out. Nobody said a word to me. My attorney didn't say a word to me, and I just said, okay, well, I'm done there. And then I realized, I thought, okay, I'm gonna have to contact these people now and do all this on my own. I don't have an attorney. I need to contact these people and find out when my next court date is, and all the, get everything done.
If it was me in your case, I'm going to tell you one thing that I would do for sure. I would get a copy of everything that's in the file that your attorney has in the file of the case. You're entitled to that. Every state has rules about attorneys must turn over the entire contents of the files to their clients, and you should get that as soon as possible. And when I say everything, I mean everything. There shouldn't be anything that attorney is withholding out of that file, because there could be something in that file that could tend to exonerate you of the charge. We know that the prosecutor does not want to give you all of the body cam tapes. We know that, and what we don't know is what other information is out there that could possibly be exculpatory in nature. So you need to get that entire file and be very vigorous about your discovery rights in the case. Criminal law, and I looked at the Arizona rules, and under the decision of Brady versus Maryland, okay, the Supreme Court has made it very clear that prosecutors must turn over all information that is involved, especially exculpatory information that is involved in a criminal case. So you should be very vigilant about that.
And to reiterate, the initial lawyer's failure to demand that is the basis for which Michael can request his money back. Isn't that right, Brian?
Well, absolutely. The lawyer was paid a great deal of money, thousands of dollars. The lawyer did not conduct, and remember now, we talked about the Arizona rules, the state bar rules, a couple of shows ago, where the lawyer in Arizona, the rules are such that when the client makes a specific request of the lawyer in Arizona, under the Arizona rules, the lawyer is obligated to follow the directive that the client gives the lawyer. And when Michael told his lawyer, his former lawyer, that he wanted him to be vigorous about obtaining the body cam tapes and whatever exculpatory evidence is out there, and that lawyer failed to do that, he actually violated the Arizona rules. And therefore, just when you go to the store and you go to the counter, when they ring your merchandise up, they want to be paid for it. And when you give a lawyer money and you say there's things that you're paying for, paying for adequate representation. Just like when you go to the grocery store, you have to pay, and that clerk accepts your money. When that lawyer accepted that money from Michael, he was responsible to do everything that was necessary for him to get Michael exonerated of the charges, and his chief responsibility was to obtain the exculpatory evidence in that case. He didn't do it. According to Michael, he actually refused to do it, and that's indefensible. He should be giving Michael every penny that Mike gave him, not part of his money, because Michael is back to square one now again.
Yeah.
He has the same charges. Actually, he's in worse shape because with his former lawyer, he's now dealing with a guilty plea that he's trying to get taken away now, that he's trying to get withdrawn right now because of his lawyer's inaction in his case. His lawyer should be paying him every dime back, because he's at the very least in the same position he was, because that lawyer did very little to nothing to get Michael exonerated of the charges.
Absolutely, and I'm hopeful, Michael, that you'll be able to recover that money. Of course, it's going to take time. I don't think too many people are just giving back 35 grand, so I do want to alert people who are watching that you can help Michael by going to his eBay store, Hats Around the World. You can just Google eBay, hats around the world, and Michael's got some vintage hats, some vintage toys, some antique items, really nice array of gifts. We've got Christmas coming up, of course, so you might want to check out Hats Around the World on eBay. Additionally, people can join Michael over on patreon.com. Michael is there on Patreon at patreon.com/Michael J. Barden, and Michael does a lot of video blogging himself, and he's posting appearances that he's made on Crowdsource the Truth as well. So we've really come to enjoy Michael's presence here on the show, and I certainly want to see justice done, and people in the audience who share that feeling can help Michael out in those two ways. Gentlemen, we're getting close to near our end here. Brian, is there anything else that we want to add? Or Michael, did you have other things you want to tell us about?
No, we pretty much covered it. I didn't want to take up too much of the show. There's supposed to be you and Brian going over lawfare and different things like that, and I just wanted to update you guys with what was going on. So I appreciate you having me on the show, and I'll let you guys get back to it.
We're pleased to have you, and we're really hopeful that what you're discovering through the revelations here on the Counterlawfare report are going to help you obtain justice, because that's the goal. So you're sort of our first case study, real-time case study, Michael, and hopefully we can pull this back from the brink for you.
If it wasn't for the help that I've got from this network of people, you and Brian, network of people, I would be sitting here on your interview talking about what it's like to be a brand new felon, and then documenting going through all this process of that. So I'm not doing that yet. So I still have hope, and I really appreciate all the help from you guys and everybody. And I hope you guys have a great night.
Thanks very much, Michael. Thanks for joining us.
We got our fingers crossed for you, Michael.
Absolutely.
Thank you.
Absolutely.
Right.
Hey, Jason,
yes, Brian.
A couple of things here. I wanted to say that at my book signing, Andy Cody from Chicago, a viewer of the show here, came from Chicago to the book signing, and we spent several hours together talking. A great guy. So had it not been for the show here, he wouldn't even known about it and so forth. So it was a great thing that resulted from the show here. And also today I got a call from a Bill from Atlanta, who actually is following Michael's case very closely. He's watching all of our shows.
Great.
So this is a good sign that we're reaching a lot of people and we're having an impact out there. We're actually showing people, we're telling people a lot of things that a lot of other people really don't want to say.
Right.
I guess it's kind of like a secret that's, things that are taking place in the background. It's kind of a hush-hush thing, and it's like a topic that's not supposed to be discussed, but it needs to be discussed. And as far as the eye for an eye law, I wish that every time a person reads about a person that was wrongfully imprisoned based on police lies and concealed and withheld information, I would hope that that person would understand that that officer, that police officer, and that prosecutor was actually paid by our tax dollars, which resulted in an innocent person going to jail. So we all have a vested interest in this issue here. And the people across the country should be encouraging an eye for an eye law. It's only fair. Some states will pay people like this gentleman, they'll give them some money, but money doesn't buy back what you were deprived from all those years.
Yeah.
We need a deterrence. And the deterrence is an eye for an eye. When a police officer lies and a prosecutor withholds information and that person goes to jail, the penalty should be that those people, the police officer and the prosecutor, should have to spend the same amount of time in jail as that person did, away from their families, without money coming in, and those types of things. So we would encourage people to keep a real close eye on this subject. It's a very important one, and we're going to be talking about it again sometime in the future, I'm sure.
And Brian, maybe what we could do is put together between you and I some sort of a boilerplate letter that people could send to their congressional representative or whoever you recommend they send it to, and then we can post that with some of the videos so people can download it, and this might help motivate people to contact their representatives and let them know that this is something we're concerned with. I'm glad to hear that people came to see you at the book signing. I think the book that you've written is extremely important, Brian, and the book, of course, is Motion for Justice, I Rest My Case. People can get it at Barnes & Noble or Amazon. The book is available in hardcover and as a digital ebook, either in the Nook format or for Amazon Kindle. And of course, Brian details his experiences being targeted and harassed by police and dealing with the corruption in the legal system there in Valparaiso, Indiana, and eventually his victory. So that was definitely a great way to achieve justice. So Brian, I think this has been a really good episode today, and we'll be back, of course, next Monday with another episode of the Counterlawfare Report. I want to wish everybody a happy Thanksgiving later this week. Happy Thanksgiving to you, Brian.
Thanks, Jason, and same to everybody out there, our audience. Happy Thanksgiving, and we hope everybody has a great Thanksgiving, and we hope you continue to watch our shows.
Absolutely. Thanks for another great episode, Brian. I'll see everybody tomorrow.
Thank you.